Hello students. In this model, we are going to discuss various types of intellectual property rights, what exactly they are, how many years they have protection, where it is applicable. So these are the points we are going to discuss in this model. Intellectual property rights are classified into patents, trademarks, copyright, industrial designs, geographical indications, trade secrets. The first classification of intellectual property rights, patents, we are going to discuss about this. What is a patent? Patent is an exclusive right granted for an invention. What is invention? Invention may be a new product or a new process or provides a new way of doing something or offers a new technical solution to a problem. The technical information about the invention must be disclosed to the public in a patent application. As we discussed before, inventors must disclose the technical information about the invention to the public in a patent application. What kind of protection does a patent offer? The patent owner has the exclusive right to prevent or stop others from commercially exploiting the patented invention. Patent protection means that the invention cannot be commercially made, used, distributed, imported, or sold by others without the patent owner's consent. Is a patent valid in every country? That's a very important question. Patents are territorial rights, exclusive rights applicable in the country or region in which a patent has been filed and granted in accordance with the law of that country or region. Means if you have Indian patent, then the patent has the rights only applicable in India. If you have the US patent, then the patent has the rights only applicable in US. So the patents are territorial rights. How long does a patent last? The protection is granted for a limited period of time. Generally, the patent has the rights, that is 20 years from the filing date of the application. So if you have the granted patent, then you have the patent rights 20 years from the filing date of the patent application. So second type of IPR classification is trademarks. What is a trademark? A trademark is a sign capable of differentiating the goods or services of one enterprise from those of other enterprises. Trademarks are protected by intellectual property rights. How can I protect my trademark? Like example, if you have a product has a name, you want to protect your product name. So you can protect your product name under trademark registration. So you can protect your trademark name. It can be obtained through registration. You can file an application for registration with the National Trademark Office. We need to pay the required fees. At international level, we need to file a trademark application with the trademark office of each country in which we are seeking protection. We can use WIPO's Madrid system. What rights does trademark registration provide? It confers an exclusive right to the use of the registered trademark and implies that the trademark can be exclusively used by its owner only. You can license this trademark name to another party for use in return for payment. Registration provides legal certainty and reinforces the position of the right holder, for example, in case of litigation. How long does trademark protection last? Term of trademark registration 10 years valid. It can be renewed indefinitely on payment of additional fees. Trademark rights are private rights and protection is enforced through court orders. What kind of a trademark can be registered? Words, combination of words, letters, numerals, drawings, symbols, three-dimensional features, shape and packaging of goods, non-visible signs such as sounds or fragrances, color shade. Another important IPR classification is copyrights. What is copyright? Copyright or author's right is the legal term used to describe the rights of the creators. So the creators have over their literary and artistic works. So what kind of intellectual works covered by the copyright? Books, music, paintings, literary works, novels, drawings, photographs, sculpture, architecture, poems, plays, reference works, newspaper, articles, novels, computer programs, databases, films, musical compositions and choreography, sculpture, films, advertisement, maps, technical drawings. So these are the intellectual works covered by copyright. Copyright protection extends only to expression, not to ideas, procedures, methods of operation, or mathematical concept as such. Copyright may or may not be available for a number of objects such as titles, slogans, logos, depending on whether they contain sufficient authorship or not. There are two types of copyright. One is economic rights, another one is the moral rights. Economic rights, which allow the rights owner to derive financial reward from the use of their works by others, where the moral rights, which protect the non-economic interest of the author. What are the rights of copyright owners? Owner has the economic right to authorize or prevent certain uses in relation to a work or to receive remuneration for the use of their work through collective management. The economic rights of a copyright owner is to prohibit or authorize its reproduction in various forms such as printed publication or sound recording, its public performance such as in a play or musical work, its recording in the form of compact disc or DVDs, its broadcasting by radio, cable or satellite, its translation into other languages and its adaptation such as a novel into a film screenplay. Another classification of IPR is industrial designs. Industrial designs constitutes the ornamental aspect of an article. It consists of three-dimensional features, shape of an article, two-dimensional features, patterns, lines, or color. What kind of protection does an industrial design right offer? Right to prevent third parties from making, selling, or importing articles bearing or embodying a design which is a copy or substantially a copy of the protected design when such acts are undertaken for commercial purposes. What kind of products can benefit from industrial design protection? Industrial design protection applies to a wide variety of products of industry and handicraft items, from packages and containers to furnishing and household goods, from lighting equipment to jewelry, and from electronic devices to textiles, relevant to graphic symbols, graphical user interfaces, and logos. Industrial designs protection. How we can protect industrial designs? We need to register industrial designs under industrial design law as a registered design. Otherwise, we need to register industrial designs under patent law as design patents. Depending on the particular national law and the kind of design, industrial designs may also be protected as works of art under copyright law. So there are three ways we can protect our industrial designs. The first way under industrial design law, the second one under patent law, the third one if the national law approves or the kind of design approves, then we can protect industrial designs under copyright law. This photograph shows how this particular product can be protected under various IPR classifications. The shoe design can be protected under industrial design. The name of the product, the name of the shoe, the brand name of this shoe can be protected under trademark. The technical ideas for the shoe making or for the shoe design or for shoe manufacturing can be protected under patent IPR classification. And if any special design can be applicable under copyright law, that also can be protected by copyright IPR classification. So these are the type of IPR classification can be applicable for this one product. Another IPR classification is trade secrets. We can protect some kind of information as trade secret, but those information should have qualifications so that we can protect under trade secrets. Those qualifications are: the information must be commercially valuable because it is secret, it must be known only to a limited group of persons, and it must be subject to reasonable steps taken by the rightful holder of the information to keep it secret, including the use of confidentiality agreements for business partners and employees. What kind of information is protected by trade secrets? Confidential business information that provides an enterprise a competitive edge. Confidential business information unknown to others may be protected as a trade secret. Type of trade secrets. Technical informations. Information concerning manufacturing process, pharmaceutical test data, designs and drawings of computer programs, commercial information, distribution methods, list of suppliers and clients. So these are the information we can protect under trade secret. Advertising strategies, a combination of elements, each of which by itself in the public domain, but where the combination which is kept a secret provides a competitive advantage. Financial information, formulas and recipes and source codes. So conclusively, these are the types of information we can protect under trade secret. Like example, financial data, techniques, formulas, patents, programs, methods, drawings, processes, technical data, list of customers. So these are the informations we can protect under trade secret. What kind of protection does a trade secret offer? It provides protection against unfair competition, but it is based on specific provisions. It is based on the case law on the protection of confidential information. While a final determination of whether the trade secret protection is violated or not depends on the circumstances of each individual case. Case by case, the trade secret protection may differ. In general, unfair practices in respect of secret information include industrial or commercial espionage, breach of contract, and breach of confidence. What kind of protection does a trade secret not offer? Trade secrets are not made public. This is the main difference between the IPR classifications. So, a trade secret owner cannot stop others from using the same technical or commercial information if they acquired or developed such information independently by themselves through their own R&D, reverse engineering or marketing analysis, etc. Since trade secrets are not made public, unlike patents, they do not provide defensive protection as being prior art. For example, if a specific process of producing compound X has been protected by a trade secret, but someone else can obtain a patent or a utility model on the same invention, if the inventor arrived at that invention independently, at that time, a trade secret owner cannot stop others from using the same. Another type of classification, geographical indications. A geographical indication is a sign used on products that have a specific geographical origin and possess qualities or a reputation that are due to that origin. In order to function as a GI, a sign must identify a product as originating in a given place. Geographical indications are typically used for agricultural products, foodstuffs, wine and spirit drinks, handicraft and industrial products. These are the examples of Indian geographical indication products: basmati rice, Darjeeling tea, Kanchipuram silk, Alfonso mango, Nagpur orange, etc. Thank you, students.